If your landlord still won't return your deposit, Florida small claims may be your next step. In the next few minutes, I'll show you when to file, how to file, what to bring, and what to say, so you walk into court with dates, proof, and a clear story. I'm Tammy Calarco, a Florida landlord-tenant attorney. I've represented both sides, so I know what judges want to see and hear. You might have clicked on this video because you're done waiting. Maybe you sent your objection letter, maybe you sent the no notice demand, but your landlord is still keeping your money. Most people think court is scary and complicated, but not small claims court. Small claims is designed to be simple. File your claim, go to mediation, then settle or go to trial. Here's what we'll cover in this video. First, should you file? This is all about thresholds and timing. Second, how to build your evidence packet that wins. Third, we'll walk through the process from filing to judgment. Fourth, what to ask for and what happens after. Now I know what you might be thinking. Tammy, if you're a lawyer, why are you telling people how to go to small claims court instead of hiring you? And it's simple, really. Not everyone needs or can afford a lawyer. Even though if you win, your landlord has to pay your attorney's fees, you still have to pay for your attorney up front. You get that money back after you win your case. For some people, that's not possible, and for others, the amount in dispute may not be worth the risk. So even if it doesn't make sense for you to hire an attorney like me, I want everyone to know how to use our legal system. Access to it is everyone's right. Just know that what I'm talking about here is only Florida small claims guidance and is just general information, not legal advice for your specific situation. Now let's dive into how to get your money back. Should you file? Think small claims court is only for big companies going after deadbeat customers? Wrong. It's perfect for tenants going after deadbeat landlords. But let's answer the big questions up front. How much can you seek? Florida small claims handles disputes up to $8,000, not counting court costs and attorney's fees. So if your security deposit in dispute is less than that, it fits. If it's over that, then it probably makes sense to talk to an attorney like one on my team. Where do you file? You have to file your claim in the county where your rental property is located. Every county is going to be different, so make sure you go to your county's website. If you can't find the information you need, there should be a phone number you can call and someone will point you in the right direction. When should you file? If your landlord never sent a claim letter by day 30 and they ignored your no notice demand, filing is reasonable. If your landlord did send a claim letter and you objected in writing within your 15 days, but they still won't budge, filing applies pressure. So run through this quick checklist for your situation. Is the amount you're seeking under $8,000? Did you follow the 15, 30, 15 deadlines? Do you have your letters and evidence ready? Do you know your landlord's exact legal name and address? If you can say yes to those, small claims court is a good fit for you. Build your evidence packet. So what's the one thing that matters most if you take your landlord to small claims court? Evidence. Photos win. Timeline evidence wins. So make sure you bring both. Think your judge will just take your word over your landlord's? They won't pick sides. They'll follow the evidence. So here's your evidence packet. Organized, short, and court-friendly. Document 1, your lease. Document 2, move-out proof. This would be things like your key return email, final walkthrough text, anything showing when you surrendered the property. Document 3, the letter trail, your claim letter, if they sent one. Copies of your objection letter or no notice demand. And certified mail receipts, proving you sent it. You can summarize these on one page and attach the copies. Document 4, your evidence. Make a one-page list of all your evidence, then attach it. Put it in clearly labeled photos from move-out date. Point out any discrepancies with what your landlord is claiming and what your evidence shows. And if you have cleaning or repair receipts, show those too. Document 5, the simple math. Make a clear statement showing the deposit amount you paid, the amount they're claiming, and the amount you're seeking. Document 6, the timeline. Have one page that clearly shows day 0 when you moved out, day 15 the refund deadline, day 30 the claim deadline, and your 15-day objection window. Then list those dates received by you from the landlord and the date your objection or demand letters were sent. Bundle everything as one PDF and on a tablet, and bring 2 printed copies for the judge and the other side. Tidy packets get faster attention and make you look more credible. You're building a case instead of just telling a story. The process from filing to judgment. If you're suing your landlord, a lot of people think court will take months and cost thousands in lawyer fees. But small claims court is different. Many cases settle at mediation the same day. So here's the basic steps in the process. Step 1. File your case. Complete a statement of claim at the clerk of court in the right county. You will have to pay filing fees, so be ready. They will also vary by county and by the amount. For example, in Miami-Dade County, if it's between $500 and $2,500, you'll have to pay $175. If it's between $2,500 and $8,000, that filing fee is $300. Step 2. Serve the defendant. The clerk will help you serve your landlord with a summons. You might have to pay a professional process server, but in other cases, the local sheriff will handle this. Step 3. Pretrial conference. The court checks who showed up, narrows the issues, and often sends you to mediation immediately. Step 4. Mediation. A neutral mediator helps you negotiate. If you settle, get it in writing, and file it with the court. Step 5. Trial if needed. In my experience, most cases settle before trial, but if mediation doesn't work, the court will set a trial date. These are focused and short. It won't be like big trials you see on TV. Just remember what judges want to see: dates, documents, photos, timeliness. If you stick to the facts, you look reasonable, and that gives you the best chance to win. What to ask for and what happens after. Now, what happens if you do win? Does the landlord owe you the security deposit back? Yes, he does owe it to you if you win. Under Florida law, you might get more. If you win, you can ask the judge for your deposit amount plus court costs and fees, like your filing fee, what you had to pay a process server, and other costs you might have incurred to prepare your evidence. But here's the thing you have to be prepared for. Your landlord still might not pay. The judge doesn't make them write you a check in the courtroom. They issue a judgment, but now you have to collect it. Ask the clerk about post-judgment collection tools. They have ways to help you collect on judgments. Now, here are some common questions I hear about taking your landlord to small claims court. Do you need a lawyer? No. You can represent yourself. But if the other side has one, you should consider getting help. How long does it take? It's going to take a few weeks, possibly a few months. After you file, you have to serve the landlord. That could take a few days. Then the landlord can, if he chooses, they can file an answer within 20 days. But in small claims court, an answer is not required. But the clerk will schedule the pretrial conference immediately. Many cases will settle at mediation on that day. So just figure it's going to take at least a month, and depending on the court schedule, maybe more. Where do you get forms? Your county clerk of court website should have small claims packets. But if you can't find them, call the court. Ultimately, the process is designed to be accessible. You don't need to be a lawyer to use it effectively. Now, hopefully, you never have to hire a lawyer or go to court. And a lot of times that can be avoided by knowing your rights and how to communicate with your landlord effectively. For help with that, you can download our Florida Tenant Security Deposit Dispute Kit. Inside, you'll get an evidence checklist and objection letter template, a no-notice demand template, the 15-30-15 timeline explainer. The link is in the description. But if you're already past that and your facts are complex, the thank you page has a link to book a consultation call with myself or someone from my team. We can get you on the right track. In my next video, we'll go over common landlord tactics and how to counter them so you can stay calm, documented, and in control if they try to pressure you. Until then, I'm Tammy Calarco. See you soon.